July is Disability Pride Month. It marks the anniversary of the Americans with Disabilities Act, ADA, signed into law in 1990. To celebrate, we'll discuss two important requirements to enable otherwise disabled employees to enjoy the same benefits and privileges of employment as their non-disabled counterparts. One, reasonable disability accommodations, and two, the interactive process to find those accommodations. So, what's reasonable? To help answer that question, we'll start with what's unreasonable and work our way back. First of all, employers do not have to enable a direct threat to health and safety. For example, many years ago, a heavy machinery operator sought my counsel because his employer took him off the job due to his heart condition. As it turns out, the employer was right. Before we could finish the analysis, he unfortunately died of heart failure. So, had the employer kept him on the job or brought him back, he could have had heart failure while operating the heavy machinery, thereby threatening health and safety. An employer also doesn't have to provide an accommodation that would create an undue hardship. In other words, providing the accommodation would be significantly difficult or expensive for the employer. Basically, undue hardship depends on the employer's size and available resources. So, what may be an undue hardship for a mom and pop shop may not for an enormous corporation. So, again, what are reasonable accommodations? While it's individualized, depending on the particular employer, job, and employee, a few examples may include making workspaces and facilities readily accessible to disabled employees, modifying or providing equipment or devices, changing job responsibilities, or changing work schedules, and that's just to name a few. So, how do we identify the accommodations? This is where the interactive process comes in. Employers, disabled employees are required to interact in good faith to determine any reasonable modifications that the employee may need that the employer can reasonably provide. Disabled employees and their healthcare providers are the experts on the employee's functional limitations, and the employers are basically the expert on the job duties. So we bring that expertise together to come up with any available ways to reasonably enable otherwise disabled employees to enjoy the same benefits and privileges of employment as their non-disabled counterparts. If you enjoyed this video, please subscribe, leave a like, and feel free to comment. Thanks for watching.